Crime in Court. My name is Heather, and this is yet another update of the Delphi case. We received a few more motions this week, and we're going to go through them. So, first of all, we received an objection to the defendant's motion to continue. So, we just continued this May 21st to 23rd hearing because the defense of Richard Allen has put out a second motion to disqualify Judge Gull. So, because of that, all other issues in this case needed to just cease until that is resolved. So, this hearing that had been scheduled was continued for whatever reason. They're objecting even after the fact. So, or maybe it just got received after the fact. Um, oh, okay. So it was filed the 20th, and um, the hearing was supposed to be the 21st through the 23rd. So they filed it the day before. So now comes, oh, here, sorry, let me shrink myself. All right, so now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to the multiple motion for continuance of the hearings of the defendant's motion to compel and request for sanctions, defendant's motion to suppress, defendant's motion in limine, oh no, I'm sorry, the state's motion in limine, and the defendant's motion to vacate the safekeeping order. Those were all the motions that were supposed to be discussed May 21st through the 23rd, all set for a hearing in Carroll County Circuit May 21st through 23rd. The state would ask the court to consider the following. Number one, so why he's objecting to this is pointless because she can't do anything about it because she's got a rule on the motion to disqualify herself. So this is a pointless motion from Nicholas McClelland. So this is just dumb. All right. Number one, so that the defense filed a motion to continue the defendant's motion to compel and request for sanctions, defendant's motion to suppress, and the state's motion in limine. Number two, that the state would like rulings on the motions set for 21st through May 23rd to adequately prepare for trial. Three, that the state does not believe the court loses its jurisdiction once a motion to recuse is filed. Are you kidding? That only applies when the recusal is mandatory, and in this case instance, it is not. I think this is a mandatory situation. Judge Gull is completely biased and needs to be removed from this case. All right. Number four, that the state does not believe the defense has listed valid reasons to grant a continuance. I think they listed plenty. Number five, that how can the defense be prepared to not at least go forward with the state's motion in limine when it was prepared on May 7th? Six, that the defense's reasons for the continuance in relation to new evidence are not well founded by the state. Number seven, that the state, but well, it doesn't, that's why there's two sides. It's not well founded by the state, but maybe the defense has some reasons that it's well founded. All right, so number seven, that the state believes the only reason the defense is attempting to continue these hearings is an attempt to delay the proceedings. Um, Seriously, because they've filed their motion for a speedy trial, and Judge Gull forced their hand to waive that speedy trial right because she didn't give them enough time to put on their case. And it's been the defense this whole time trying to go to trial and trying to make things more transparent to society, letting us all know what's going on in Delphi or Carroll County specifically. Number seven, that the state believes the only reason the Delphi is attempting to do this is to delay the proceedings. We just read that. Number eight, that the defense did contact the state and the state did notify the defense that they object to this continuance, but the defense did not state that clearly in their motion. That's a lie because they did say that the state objected in their motion. I remember reading that. Number 9, that the state objects to any continuance of the hearings set for May 21st through the 23rd. Wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and files this objection to the defense's motion to continue the proceedings set for the 21st through, oh, now it's the 24th. He got that wrong. All right. So that was Nick's motion to object to the continuance. And here's the defense's response. So comes now the accused, Richard Allen, by and through counsel Brad Rosie and Andrew Baldwin, and files his reply to the state's objection to defendant's motion to continue the upcoming hearings on May 21st through the 23rd. Number 1, the state made an erroneous comment in paragraph 8 of their objection to the defense's motion to continue, claiming the defense did contact the state and the state did notify the defense that they object to this continuance, but the defense did not state that clearly in their motion, and that's what I just said. That was a lie. They clearly stated it in their motion. Dog's just back from a walk. She's all panting. All right, number 2. Paragraph 17 of the defense's motion to continue states the following, which notes the state's objection. Quote, the prosecution has been contacted and does object to this request. I mean, couldn't have been any clearer that they said you do object. Number 3, the defense clearly stated that the prosecution objected to their request and is not sure why the prosecution believes that was unclear. Me either. Number 4, the state of Indiana cites no case law to support in proposition that a continuance is requested due to the pending request to disqualify Judge Gull, nor does he cite any case law negating the case law provided by defense counsel that supports the defense's position that a continuance is required due to the disqualification motion. All he says is that the state does not believe the court loses its jurisdiction. Okay, so just because the state believes that doesn't make it so. The state believes that the court loses that the court state does not believe that the court loses its jurisdiction once a motion to recuse is filed. This only applies when the recusal is mandatory, and in this instance, it is not. He doesn't cite any case law. He doesn't cite any reasons why he came up with that argument. So, why? Number 5. Furthermore, sorry, what did I finish reading the defensive motion that I continued? Okay, sorry, in my head. Number 5. Furthermore, again on May 15th, 2024, the prosecution provided a new phone extraction that the defense believes will be useful for the defense at the motion in limine hearing, but needs additional time to review this voluminous, sorry, words are hard sometimes. Voluminous extraction, as well as the anticipated report that will be filed by First Sergeant Christopher Cecil that will also be useful at the motion in limine hearing. So there is something in this latest phone extraction that the defense thinks might be potentially very useful for them at trial. So that's interesting. And they just received this extraction on the 15th. They were supposed to go to trial on the 13th, so technically it's a little late, but hence I think more the reason why they've waived their speedy trial rights because they haven't received all of the information yet, or who knows, because the state just keeps throwing all this discovery at them, some of which has nothing to do with the case. Basically, I think in an attempt to delay their ability to represent their client. All right, and then lastly, number 6, it is surprising that the state in Indiana would object to a continuance of the motion in limine hearing when the state of Indiana only produced a piece of evidence that will be used at said hearing less than a week before said hearing. So they didn't turn over any other than one piece of evidence. They didn't turn over the rest of their evidence or things that they would like to argue in their motion for limine. So wherefore, that's basically where they argue things that can and can't come in. So they might say, like, we want this police report not to come in, and we want these photos to come in, or whatever. Like they might arrange pre-trial what they want, what evidence to bring in and whatnot, and what things to talk about. Because Nick McClelland wants the defense to not talk about anything Odinist related or ritualistic related or runes, anything related with runes, anything that, has to do with their theory of the case. They want to get rid of their ability to defend the client. So that's what's going on there. So they want the court to wait, wherefore the accused by and through counsel offers his reply to the state's objection to the defendant's motion to continue. So that's all of those. So what do you guys think about that? Very interesting that Nick felt the need to get all those items out there as to why he objects and the whole thing about the being totally disingenuous about the fact that the defense mentioned that they did object, the state objected. So that's what's going on with the defense and the prosecution. They're still going back and forth with everything, and Judge Gull is still receiving more communications from the public regarding the way that she's dealing with this trial, the way she's managing it. So let's read this ex parte communication from Hamilton Berger. This was dated May 22nd. Greetings, Your Honor. I trust this missive, finds you basking in the glow of judicial wisdom and not overwhelmed by the circus that the defense team has so graciously provided for our amusement. I must commend your extraordinary patience, a virtue that seems to rival even that of Job himself in dealing with the unparalleled spectacle presented by the defendant's attorneys. One must marvel at the sheer audacity of a defense team whose legal prowess can only be described as a master class in sloppiness, negligence, and incompetence. I have a feeling this is very written in tongue in cheek. It is as if they attended the Perry Mason School of Law only to graduate summa cum laude in the fine art of courtroom buffoonery. Allow me to paint a picture, if I may. Here we have a defendant whose guilt seems as obvious as a skunk at a garden party. This is a man who could qualify for the Guinness Book of World Records for the most confessions made, except, amusingly, none of them seem to be to his own defense team. He's confessed to everyone from the warden to the cafeteria lady, but apparently the only people he's keeping in the dark are the lawyers trying to defend him. And speaking of performances, Mr. Hennessy's contributions, Mr. Hennessy is the attorney for Richard Allen's attorneys, so for Brad, Rosie, and Andrew Baldwin. He was their attorneys for the sanctions, or not sanctions, the motion to find them in contemptuous conduct. All right, so, and speaking of performances, Mr. Hennessy's contributions are pure comedy in the style of Jerry Lewis. His reputed fondness for a tipple adds a delightful unpredictability to the proceedings, and his legendary spelling and proofreading deficiencies make his legal briefs read like Mad Libs. Let's also not forget his memorable declaration that the defense team was snookered by a trusted friend in their leaked photos scandal, which added a touch of billiards humor to the legal melodrama. Furthermore, the defense team's constant requests for delays after demanding a speedy trial is a masterstroke of irony. It's like demanding a fast food order and then asking the chef to slow cook it to perfection. One can only admire such strategic confusion. As if that weren't enough, we have the introduction of the Odinists, or should I say, the Odinites, as the defense team so charmingly refers to them. It's as if they decided to sprinkle a bit of Norse mythology into the legal proceedings just to keep things interesting, right? Like, why would they bring that up otherwise? Because you'd just be made fun of for bringing it up, especially if it's not true. I mean, you would only bring it up in cases where you have extreme amounts of evidence proving this. All right, so next, we might expect Thor himself to be called as a character witness. That would be great. What's Chris Helmsworth doing right now? Isn't he? Didn't he stop acting, or was it the other Helmsworth? I don't I get them confused. But he was Thor, Chris, right? Chris Helmsworth. All right, so your tolerance of this defense team's shenanigans is nothing short of saintly. It is reassuring to see a competent, seasoned judge reigning in the chaos with the poise of a true professional. Yet one must wonder how much longer you can sustain this Herculean effort without putting an end to this tragic comedy. Is it too late to reconsider your previous leniency and find them in contempt? In all seriousness, Your Honor, the time has come for the curtain to fall on this farce. The defense team's performance has been less To Kill a Mockingbird and more The Three Stooges. While I do appreciate the entertainment value, justice for Abby Williams and Libby German demands a swift and competent resolution. In conclusion, may I suggest a toast to your unparalleled patience and fortitude. Here's to hoping that the defense team's next act includes a modicum of competence for the sake of all parties involved. Yours in judicial admiration, Hamilton Berger. What do you guys think about that? Was he serious about appreciating Judge Gull's way in which she's dealing with this case? I mean, it seems like it's written to me very tongue in cheek. So I don't think he's really commending her for her um, actions in this case, but that's just me. That's how I read it. But you guys let me know what you think. He could very well be a Richard Allen Gilder. We do not know. All right, anyways, next is the ex parte communication from Mike O'Leary. Don't blink because you'll miss it. Here it goes. From Mike O'Leary, subject line says you need to step down with, I think, 5 exclamation points. And it says, I am 73 years old and I have never seen such a circus as you have performed as a judge in the Delphi on a Livings case. You need to go home and stay there. Mike O'Leary, Indianapolis, Indiana. I agree with his sentiment 100%. She should not be on the bench anymore. She is clearly showing bias, and I think she needs to not just step down from this case, but from all her cases. Step down from the bench. You have shown your bias, Judge Gull, and that's not okay. That's not what being a judge is about. So I think it's time for her to step down. What do you guys think? Do you think she'll step down on her own? Do you think there will be enough of a public outcry to have her leave the bench? I think it could get to that point if she continues with this garbage that she's pulling, these shenanigans. So let me know what you guys think down below. And don't forget to hit the like button on your way out. And I hope to see you guys in the next one. Thank you guys so much for watching. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.